Good evening, students, academics, practitioners, ladies and gentlemen. My name is Deverell Capps and I'm the Director of Strategic Development here at Northumbria Law School, and it is my absolute delight this evening to welcome Mark Stobbs for our penultimate Eldon lecture. Mark is no stranger to Newcastle. He was born here, educated here, until he went off to Oxford, that is, to do a law degree. Following his graduation, Mark went to the Lord Chancellor's Department for 8 years, and in 1993 moved to the Bar Council, where he worked in the Complaints and Standards section. Mark worked there for 5 years before becoming promoted to the head of professional standards, and during that period, under his leadership, he reformed the Bar Council's complaint system, developed the rules relating to barristers' public access, and oversaw the rewriting of the Bar's Code of Conduct. In 2004, Mark was elevated to Deputy Chief Executive of the Bar Council and set the wheels in motion for the Bar Standards Board. And in 2006, Mark became the first Director of the Bar Standards Board. In 2008, Mark left the BSB and went to the Law Society, where he took up the role of Director of Legal Policy. And during his time at the Law Society, he's looked at legal aid and access to justice, advocacy, law reform, and also the Law Society's international role as well. Mark is a good friend of Northumbria Law School. I first met him 14 years ago when I invited him up to come and do lectures to our bar students on the Code of Conduct and professional standards. And he made probably about 7 or 8 trips since 1998 up to Northumbria for our bar students. And so it is with great delight this evening that I welcome back Mark to deliver this Eldon lecture and talk about what do you mean you're a lawyer, the future of legal practice after the Legal Services Act 2007. Mr. Mark Stobbs.
Thank you very much indeed. Good evening. It's a great honour to be invited to give this lecture and a pleasure to be here in this rather wonderful new building that you've got. It's also nice to be giving a lecture in a series that's named after one of the former scholars who went to my school and went on to achieve high judicial office. I want to talk tonight about how ideas of being a lawyer have changed and what legal practice means, and how these are going to develop over the next generation, particularly following the changes in the Legal Services Act. In doing so, I should make it clear to start with that I'm doing this entirely using my personal views. There will be quite a lot of people back in Chancery Lane who may well disagree with what I'm saying, and many in the profession may not like it at all. If I get things wrong, blame me, not the Law Society. I thought I'd begin by looking at the views of two practitioners who knew the profession as it was in the relatively recent past. I don't say that they provide a fully accurate view of what the profession was like, but the attitudes are interesting and illustrate how perceptions have changed. The first one, arrived by pure happenstance. A couple of weeks ago, our president received a letter from a solicitor who'd been entered on the roll in 1952, 60 years ago, and he wrote to voice his concerns about the state of the profession, which he said was very different from in his day. Here's some of what he wrote. In those days, we were interviewed by the Council of the Law Society, to see whether we were the sort of person who would be likely to do the profession credit, the prevailing notion being that solicitors were entitled to think of themselves as gentlemen. It was also an absolute rule that solicitors should not advertise their services to the general public. Solicitors have to a large extent ceased to fulfil the role which they were once proud to lay claim to, and are now bracketed with estate agents and bankers as people chiefly concerned to meet their own ends. The worrying thing is that the profession is now hugely involved in antisocial activities. The legal aid system has been abused to the extent that it is now a major burden on the taxpayer. The no-win, no-fee industry, which relies on advertising, which was forbidden to a previous generation for very sound reasons, is now responsible for substantial rises in insurance premiums, and integrity seems to have gone out of the window. I think there's a huge amount there that modern lawyers would quarrel with, and perhaps I shouldn't be too hard on an individual who must now be at least in his 80s, who may well have rose-tinted spectacles of what it was like at the time. Probably doesn't realise that the legal aid budget would be exhausted in a few weeks by the National Health Service and in a few days by the defence industry. I'm personally not sure that there is anything wrong with a no-win, no-fee system by which lawyers are able to finance people to obtain access to justice and obtain redress that they would not otherwise have got. I don't think there is any substantial evidence that ethical standards have dropped, or whatever the insurance industry may say, that unjustified claims are actually being paid. And perhaps this man's use of the word gentleman is understandable at a time when, at the time when he was admitted, there were 20,000 people in the profession, and only 400 of them were women. And the average rate of women joining the profession in the years before then was 13 per year. But the profession, you had to remember, had a very different role in those days. And much of its role was actually to advise gentlemen and their families, to be, as a later commentator put it, to be the preservers of their property. But I think also what he was trying to say was that solicitors were respected because they could be trusted as people of integrity and who served the public interest. I want to discuss a little bit more about those qualities of integrity. And perhaps it's simply our view of the way in which people and professionals should run themselves, how they should act in the public interest, which has changed. And that later made me think of myself 30 years later, in 1982, when I was considering my career options and about to start a law degree. And one of the books I then read was Glanville Williams's Learning the Law. By that stage, it had reached its 14th edition. He was a barrister and a QC, and even then I found his written style rather quaint and patronising. But it's worth looking at what he said about the profession then. I can't resist beginning with the quote, "The life of a successful solicitor is not so exacting as his opposite number at the bar." He went on to say, "The work done by a solicitor is well known. On the property side, he investigates the title to land, prepares contracts of sale, conveyances and wills, obtains probate of wills, and frequently acts as executor and trustee. He interviews clients and advises them generally on their legal position and writes letters. He pilots company promoters through the legal technicalities of forming companies. On difficult questions, he takes the opinion of counsel, and he prepares briefs for counsel in legal proceedings in which counsel is instructed. A few very large and affluent city firms have adapted themselves to act as the agents and advisors of commerce and industry. They have modern offices with every aid and convenience, and the partners specialise intensively. They can be asked, for example, to draft and help negotiate important commercial contracts of all kinds. These firms may even have overseas branches." At that time, there were around 44,000 solicitors and about 4,400 barristers in practice, the profession having doubled in size since 1952. And he goes on, "Over the years, the solicitor has slowly lost the prestige he formerly held as a family counsellor and preserver of the family property. Lawyers are being criticised for being slow to adapt to demand for new legal services, particularly services to the poor." He identifies conveyancing as the major source of the profession's income and deals very presciently with a number of the likely problems facing both professions. He doesn't suggest that it was a promising career if you are female or from an ethnic minority. And, interestingly, again, a slight change from our gentleman of 30 years before, he recognises that the demand for services for the poor perhaps isn't fair to solicitors who do have businesses to run. There are some omissions there. which I find quite interesting. The first is the complete absence of any reference to legal aid, to criminal and family work, to judicial review and public law. And secondly, there's very little discussion of the regulatory system governing either profession. Their codes of conduct, the bar had only just got its first ever code, or the rules and ethos of those professions, what being a lawyer was about. It appears to be, from there, about managing people's work, people's lives. It's mostly non-contentious. There's not a lot about access to justice, about giving people the rights that they have and which the law grants them. It's not about it doesn't talk about the duties that lawyers owe to their clients, the duties that they owe to the court, the requirements of integrity that are there. Now, there are a number of things which both our 80-year-old correspondent and Mr. Glanville-Williams would recognise today. Solicitors still do all the things that were suggested there, and they are still overwhelmingly likely to instruct a barrister to appear for you in the higher courts or to provide advice on difficult areas of law. But quite a lot's changed. First, the size of both professions in the 30 years since then has tripled. There are now 125,000 solicitors in practice. There are well over 15,000 barristers. 40% of solicitors, in other words, the entire size of the profession in 1982, are employed in the top 100 firms. Most of those firms not merely have overseas branches. One of them is the largest firm in Germany. Two of them are the largest global firms by income and by size in the world. They're working in a global environment. Solicitors specialise far more than they used to. It's not simply the city firms that limit themselves to specialised commercial work. Some firms simply do conveyancing. Until 2008, some of them were making very respectable livings just out of doing remortgaging work. You have boutique firms dealing with particular areas of law where they have the specialisms. There are still a number of traditional firms, there are plenty of small firms, but the proportion is reducing. Those sole practitioners, who I suspect made up a very substantial proportion of their 20-odd thousand in 1952, are now less than 2% of the profession. Numerically, they remain about constant, but the proportion continues to go down. In addition, new professions have grown up. It's not just the solicitor-barrister dichotomy anymore. Licensed conveyancers were established in 1986 as a way of enabling conveyancing specialists to compete with solicitors in this area of work without having to go through the whole rigmarole of qualifying as solicitors. Legal executives, who in the 1980s were the clerks who gradually worked their way up, and a number of whom became solicitors but were non-graduates, have now, as legal executives, gained the rights to do a number of the pieces of work which were limited to solicitors. Patent agents, trademark attorneys, law costs draftsmen are all part of the regulatory structure that now exists, who can do work that only lawyers can do. And this provides a greater diversity to the profession and a greater choice for consumers than it did before. And the regulatory systems changed unrecognisably. In 1982, both professions were governed by their respective professional bodies, with their representatives elected by the profession. Lay involvement was absolutely unknown, and they had pretty much carte blanche in changing their rules and making their rules. Solicitors' rules had to be approved by the Master of the Rolls, but they were very rarely rejected. The Bar Council could do more or less what it liked. Now, each body has been required to establish an arm's-length regulatory body, with at least an equal number of professional and lay people on board. It's overseen by the Legal Services Board, which has a lay majority, and the Law Society and the Bar Council have the mixed blessing of supporting those regulatory arms, but having very little power indeed to interfere in their decision-making or affect what they do. And a single service exists to look at consumer complaints against all bodies, against all lawyers. There's now significantly greater movement between the two professions. I can remember the time when you had to disbar if you were a barrister and you wanted to transfer to be a solicitor. You were not, if you went to work in the solicitor's office, you could not describe yourself as a barrister, no matter how long you had worked and practiced as a barrister. Even 5 or 6 years ago, a very distinguished and eminent Attorney General had to take further exams in order to become a partner in a solicitor's firm. This has all changed, and quite right too. I think it's worth looking at the reasons for some of these changes. I want to look at the economic reasons for the growth of the profession. I want to look at the way in which work has changed, at the competition changes, and at the changes in regulation. There has been an exponential growth in the work available to lawyers. Public law, employment, education, immigration, human rights, competition, myriad of others, which simply didn't exist in 1952, have grown up and have created work for lawyers. The Labour government famously created 3,000 criminal offences. Again, providing work. A tribunal system which explicitly was designed to work for lay people only and not need legal advice, has now managed to develop a jurisprudence which is so complex that you would be very well advised as a claimant to be represented by a lawyer there, particularly since in the employment tribunal you can be absolutely sure that your ex-employer will be represented by one. Lawyers have gained roles as compliance officers. They advise companies not just when they've broken the law, but on how to avoid breaking it. A greater industry. And it means that, again, there is greater specialisation. You cannot, as a lawyer, understand this whole range of law that you might have been able to do 60, 80, 100 years ago. The growth of globalisation and multinationals has provided the economic means for the large city firms to make their money. English law has become one of our most successful exports. It accounts for about 2% of our gross domestic product. The legal profession contributes 25 billion to the GDP of this country. It's a major contribution to the prosperity of our nation. I think one of the reasons for this lies in the trust that people have in the English legal system, in its judges and its lawyers. And that says something, I think, about the integrity and respect of the profession which exists abroad, even if it doesn't exist here. There's also been the change in social mores. Divorce is now acceptable. People have become less tolerant of things going wrong. They're aware that they have rights, that they're able to get redress. They also tend to have some money. They can afford to take actions. They can afford to take money to pay lawyers to get things right. And the change in the rules allows lawyers to market themselves more. It allows them to advertise, to let clients know that they exist, to let clients know that when things go wrong, there is somebody that they can go to sort it out. And there's been a further byproduct of this, which is the growth of the consumer, and particularly their representative organisations. Now, most lawyers I speak to, when they hear the word consumer, grown. They see them as nuisances, particularly the representative organisations who don't understand the complexities of the law, who don't understand how difficult it is to be a lawyer, and really just ought to shut up and let lawyers do what they say. I think it's a fairly common psychological problem in a number of service industries that people would rather not engage with the people who pay for the service they provide. I sometimes think it would be a lot easier to run the Law Society if there weren't any solicitors. It would certainly be easier to have run the Bar Council without barristers. That's a pretty short-sighted approach. And with hindsight, I think the failure of both professional bodies properly to engage with consumers, with what clients were looking for, is one of the main reasons why self-regulation had to go, and why something which was perceived to be independent, and where there were people there who were able to look at things from a different perspective from that of the legal profession, needed to be put in place. So far, I've given a rather optimistic view of the profession, one that's grown hugely, that has lots of money available to it, lots of clients that are willing to instruct it. Lots of the practitioners in the audience won't necessarily recognise that. They will be aware of the problems and the competition that they face. And I'd like to have a quick look at those challenges that they're facing. We are moving into an age of austerity. The legal aid budget is going to be cut by 24%. That's going to mean that from a budget of approaching 2 billion, 300 and odd million will come out of it. Money that will no longer be available to the profession. This won't affect a vast number of solicitors' firms because less than 10% now do legal aid work. But those that do will find their business model seriously affected. There will be fewer clients and they will be paid fewer fees. There's been a 10% reduction in the fees for criminal work. The bar will be hit substantially more badly. 40% of them do some sort of legally aided work. Then there are the reforms to civil costs recovery, where the amount of money available for lawyers' fees is going to be reduced. You will no longer be able to recover from the other side, usually the insurer, the success fee in a conditional fee agreement. That will have to come out of the client's damages. And the percentage of damage, the percentages of those damages that can be used towards that success fee is going to be heavily capped. In a number of the smaller cases, I seriously wonder whether it is going to be worth solicitors taking that work on, at least in the way in which they are currently organised. And I think this is partly a result of a perception caused by very keen lobbying by the insurance industry that the cost of bringing cases is simply too high. It needs to be reduced. The easiest way, rather than actually make the processes more efficient, is to reduce the fees. They also want to reduce the number of claims. And I think the reforms in Part 2 of that bill may well do that. Unless, of course, lawyers start looking at their processes. Do you need to pay a lawyer to do all the work in a personal injury claim? Can you outsource it to somewhere much cheaper? Can you invest in some technology to computerize? A lot of firms do that, but there is still more that they can do. And I think the choices that lawyers are going to have to make in deciding whether they want to continue this work will be over whether they need to do it themselves, the sort of person who they will be paying to provide it, and the level of service that they can provide to the client. I suspect a lot of very simple cases may actually continue. It will be the difficult, the borderline ones, the complex ones, where you need some expensive lawyer input that may no longer be taken forward. There are wider attempts, actually, to take lawyers out of the system as well. Some of this is going to come in the employment reforms. If you can only bring a claim against your employer if you've been in post for 2 years rather than 1, that's going to reduce the number of claims for employment lawyers. The Borders Agency in immigration cases writes directly to clients. They don't want to correspond with solicitors. The Criminal Injuries Compensation Board doesn't want applicants to use lawyers. So they make it as difficult as possible for those applicants to actually get the money from their compensation to pay those lawyers. There's a well-known practice by insurers called third-party capture. What happens is that you have an accident. 6 hours later, you have a call from the insurers of the person who caused the accident saying, "We're really sorry about the accident. Do let us give you a cheque for £1,000 in full and final settlement." This is, of course, before the client has had a chance to establish whether there is any case to bring, before they have the chance to assess the nature of the injury or the likely damages. But they probably feel okay at the time, and in fact, they may not even intend to bring a claim. But the insurance companies reckon that it's probably easier just to give out some free money to people than risk the expense of a claim. And all of this is moving towards getting lawyers out of the market. And of course, clients themselves are going to be looking for a cheaper deal, even when they decide they need a lawyer there. They will be saying, what is the lowest price you can do me for this? Do you have to do all of this in your expensive London premises? Can you outsource the work to India, to South Africa? And many firms are doing that. This isn't necessarily a new thing. It began, I suspect, when solicitors realised that it was far cheaper to use a young barrister to go along to an easy hearing in the county court than to do it themselves. That you could employ people who were significantly cheaper and unqualified to do the work. It's just that those people, rather than being in the office, are abroad. Then there is the increased competition within the profession itself. One of the more unedifying things over the last 5 or 6 years has been the debates between the criminal bar and criminal solicitors over rights of audience. It arose when the bar managed to negotiate for itself very advantageous advocacy rates for legal aid, with the result that the rates that solicitors were going to be paid for preparing the cases went down. With a bit of prescience, you might have thought, in fact, what solicitors would then do would be to qualify to appear in the higher courts and take that work themselves, which a number of them did, with the result that the bar is finding itself heavily squeezed and is making a lot of noise about what it believes are poor advocacy performance by solicitors. There may well be poor solicitor advocates. I'm absolutely certain there are poor barrister advocates, and at least the advantage to the client of having their solicitor appearing for them in court is that actually they know they will get their advocate of choice on the day, rather than someone who may have been sent round the night before. But the bar are also trying to compete with solicitors in access to clients. When they lost the exclusive rights of audience, the obvious thing to do was to try and get at the clients themselves. And this, I think, has become a substantial piece of work for the bar, or for some sections of the bar, particularly where the clients they have are planners, are sophisticated, who don't feel that they need a middleman to go there. And then there are the people who have realised that to do a lot of legal work in this country, you don't have to be qualified at all. You only have to be qualified as a lawyer to appear in court, to issue proceedings in court, to do conveyancing, to do probate, not to write wills, and to do some immigration work. This gives a lot of scope for people to write wills on behalf of clients, to appear as employment advisors for them in tribunals, and to do a lot of the preparatory work before proceedings are issued in civil cases. And claims managers have made a considerable living out of this. A lot of these people say that actually they are creating a new market for legal services. Many people, they say, are afraid to go to solicitors and barristers. They are intimidating, unfriendly, not for the likes of us. Whereas a claims management firm which advertises on television with nice friendly people on the telephone taking your details, much more accessible, much easier for them. And solicitors have not moved into this market. They've preferred to pay them for doing the work so that they can take it on later through a referral fee. And these people don't have the same regulatory costs that solicitors have. And this causes a substantial amount of discontent within the profession. If you're a specialist solicitor dealing with wills and probate, you are contributing to a cost of regulation of about 80 million, payments into a compensation fund of 20 million. You will have to cope with professional indemnity insurance, which again is worth about, which costs the entire profession around 250 million. There are the unseen costs of compliance in complying with a code of conduct that increasingly is requiring you to send out client care letters, which is requiring you to do identity checks, anti-money laundering checks. You have to do conflict checks as your firm gets larger. You have to pay for compulsory continuing education, unless you come and listen to me when you don't have to pay at all. And these are all the overheads that a solicitor's firm, and to a lesser extent the bar, have to face, which I, as an unqualified person, sitting in a serviced office, putting out a bit of marketing about a will, don't have at all. And I can charge substantially less, and the consumer will think I'm doubtless very friendly. I've produced them a nice will on cheap, on expensive paper, and they're in no position at all to know whether it will achieve what they want. They're in no position to know whether or not I might disappear tomorrow and the copy of the will disappear as well. And there has to be a debate about the extent to which that provides proper support and proper service for consumers. And now I'd like to move on to alternative business structures, ABS, which potentially is one of the most interesting challenges that solicitors, barristers, and existing providers of legal services face, because they are regulated on exactly the same basis as lawyers. They just have much more money. The alternative business structures it's a horrible term. It's going to be abandoned, or it must be abandoned sooner or later, as I believe these structures are going to become the norm for legal practice. There will be nothing alternative about them. You will be slightly odd if in some way you are not part of an ABS. This is because it covers a multitude of different practice areas, of different ways in which businesses can be conducted. At one end of the scale, you have the position of the non-lawyer finance director or human resources director who becomes part of the board, is brought into the partnership, becomes a co-owner of the company. I think quite a lot of medium to large firms have a number of unqualified, legally unqualified people who are actually essential to the way their business runs. I think they will want to keep them, to encourage them, to bring them onto the board and into the partnership. The next is where a firm is bought up by outside equity, issues shares on the stock markets, does a Goldman Sachs. I think a number of the large city firms may find that too attractive to miss. And it will enable them to get, they don't need the finance, but it will be a very nice gift for the partners. I think, but also, this will enable them to get, the smaller firms, to get some outside investment, to move from being a local firm to a regional firm, from a regional firm to a national firm, from a national firm to an international firm. Providing a level of investment which the individual partners and directors cannot currently contribute. Then you have the more interesting ones, or I find them more interesting, where you have potentially different professionals getting together. So you could have a group of accountants and lawyers in partnership to provide tax advice. You could have Max Hastings, Max Clifford, and one of the major libel sets in London, and Peter Carter-Ruck, going into partnership to provide media advice. You could have local planners, surveyors, solicitors going into partnership to provide a one-stop service for builders, people looking for that sort of advice. And finally, there is the acronym of Tesco law, which people tend to use when they think of ABSs, where a big supermarket, an insurance company, decides to add legal services to its remit because it thinks it will bring in more customers and it can add value. So you go to the co-op, since the co-op has announced it's going to do it, you do your groceries and you buy a will on the way out. It's too early to tell exactly how this is going to work in practice. The first licenses haven't yet been given, but they're due to be given sometime in the next few weeks. We know who some of the applicants are because they've told us, but we don't know who they all are. If you'd asked me a year ago, I would have said that I thought the co-op might well be interested in doing conveyancing. It might well be interested in doing wills. It has, let's face it, a funeral service. So you buy your funeral power plan, you get your will, and they'll do your probate afterwards. It makes a lot of sense as a consumer. They might do road traffic accident work as well. I suspect a number of insurers will find that attractive. I thought they might shy away from contentious work. I'm not sure how good it is for your brand as a supermarket if one of your customers receives a letter from Co-op Solicitors PLC about the divorce from your ex. It might just affect your willingness to continue to shop there. You would have thought they've hired 2 extremely distinguished family solicitors to develop a family practice. And it seems to me that when a body like the Co-op does that, that is something that we should all sit up and notice. We also don't know how far they're going to create new markets. I talked earlier about people being intimidated by solicitors and barristers and the legal profession. People who might not go to a solicitor's firm might well go to a co-op for their will. A very high proportion of people here do not have wills. There's a market there. They might well go for their conveyance. But I think it's likely that they will have better marketing than many local solicitors' firms will have. They will have the history of customer service, so they will actually make you want to be advised by them. And they will be cheaper because they've put the investment in for the people, for the technology that will make it cheaper. There'll still be people who want to go for a proper solicitor, but I suspect that the number of high street firms is going to be significantly reduced in the coming years. So they'll have to adapt. And how do you think they might do that? I'm always slightly surprised that they don't actually seek to get, that the existing high street firms don't seek to have a greater relationship with some of their middle-income clients. I had a conveyance recently. Very efficient firm did it for me. They sent me a letter saying, and really you ought to think about your will. Our wills partner will be in touch in 2 or 3 weeks. I'm still waiting. There are quite a lot of things in my life when I might actually need some advice. When I'm moving job, when I want advice about the sort of pension I ought to be having. When I might have a bit of difficulty at work and want some advice on my employment rights or over the contract. Why shouldn't solicitors try and engage more with me about my needs? And I'm not sure that the high street is the only part of the market that will be affected. Many of the commercial firms tell me that they don't think that it's going to apply to them. I think it might. I think a firm of accountants or a firm of management consultants who are providing advice to industry about where they are moving strategically, about their management structures, their procedures, how you might do a buyout, might well want to offer the legal service as well. And they can employ the lawyers to do it. I think the bar is slightly better placed to weather this. As I mentioned earlier, young barristers are extremely cheap and they're extremely willing to go along to court hearings and to do work very cheaply, probably more cheaply than somebody employed by an ABS could do. I think the stars at the top end will continue to be able to command what price they like. I think the people in the middle, the people who are finding their work being taken by solicitors in crime, who don't have a particular niche or practice or piece of work, might well find it attractive to move from self-employed practice and move into one of these firms. I think the whole structure of the way in which services are provided will change. And a lot of lawyers are going to be worried about how this affects their independence and their integrity. And perhaps this is the time to discuss this briefly. Lawyers have duties to their clients, they have duties to the court. The duties involve taking decisions which are against those lawyers' personal interests. There is a conflict, you have to send the work away. Your client puts you in a position where you're faced with misleading the court, you have to take the work, send the work away. Your client, it is in your client's best interest to settle a case. You have to advise them to do so, even though fighting the case in court will be financially massively more lucrative. If you're part of an avowedly commercial company, how will you manage those duties with the commercial imperatives? What pressures are you going to be under to avoid offending an important client? And will your boss or your shareholders understand if you take those decisions? How far are they going to support you? Will they become risk averse? Will this mean that the difficult cases, the controversial cases, just won't be brought if these are the only bodies able to afford to bring such cases? We need to see how the regulatory system copes with that. The duties are clear. There are people in these firms who will be personally responsible for ensuring that you comply with them. And doubtless there will generally be compliance. But will those difficult cases be taken? Or will there be a group of firms outside the ABS structure who will be proudly independent, will market themselves as such, and carry those forward? The other thing this will do, which I think is a good thing, is to avoid the muddying that's happened of the way in which a lawyer practices with integrity and independence and so forth. Until 12 years ago, the Bar's Code of Conduct said that its sole purpose was to keep and maintain a group of self-employed advocates who were, by definition, in the public interest. The argument was that you could only manage your duties to the court, to the client, if you were self-employed and independent. That was patent nonsense, as any self-respecting solicitor would have told you at the time. I don't believe that it is beyond the wit of man to manage integrity in a corporate environment, to manage professional duties. The co-op, the major firms, have their reputations to maintain. It will be in their interests to provide the services, to do it properly. And it seems to me that they will be under sufficient scrutiny in the early years for this to be very likely to work. Let me move on finally to the question of qualification as a lawyer and the regulatory structure. I've said that lawyers are increasingly specialised. I've said that we've seen a group of professions growing up. It seems to me very likely that the problem with will writers that I described earlier will lead to you having to be properly qualified and regulated in order to write wills. Now, a solicitor's training in wills, you have to do between, I understand, 7 and 15 hours. You don't have to do any examination to prove that you're competent in it. You develop your competence in training and by working with somebody more senior and experienced until you get that level by doing your continuing professional development. If you have a specialist will writers regulator, off-will or whatever, they are going to require their applicants to take exams. They're going to require more than 7 to 15 hours training in writing wills. Will you get a position where, in fact, these people can market themselves as proper will writers? Will that change the general practice view of a solicitor? Now, the general practice view has its advantages. It means that you have a much wider view of the law. When something funny comes up, you'll be able to spot it. But for the vast majority of wills, is that necessary? And the way in which this will, I think, develop is shown by what the regulators are doing over quality assurance for advocacy, where if these proposals go through, you will have to show after 5 years that you remain competent to exercise rights of audience in the magistrate's court. That will mean that 100,000 solicitors, at least, who currently never set foot in a magistrate's court and probably have not the smallest intention of doing any advocacy, will lose the rights which theoretically they have at the moment to appear there. This causes quite a lot of excitement among some practitioners. I fought for my qualification. I want to keep it. You can't take my right away from me, even though I don't use it. I don't think that is an acceptable approach or one which will work with the regulators anymore. If you don't use it, why do you need it? And if you don't use it, you're probably not really competent to do it. So therefore, you shouldn't. And as people get more specialised, as people say, why do lawyers have this special right to do conveyancing, probate, appearing in court, advocacy? I think lawyers are going to have to develop and demonstrate their competence. And I think this is going to help consumers, because most consumers actually are not very well equipped to judge whether a lawyer is any good or not. They may use a lawyer 2 or 3 times in their lifetimes, if at all. They know by word of mouth, if they're lucky, whether anyone is any good or not. There is going to be a demand for something which shows you whether that lawyer is good. The Law Society has accreditation schemes at the moment, but really those only passport you into legal aid work. And most of the clients who use those, who use lawyers on those schemes, will be legally aided. I have no doubt that in privately funded work, such accreditation is going to become essential and probably required by the regulators in order to do it. This is going to cause some concern in the profession. I think it's in the profession's interests to do it. And I think it's also in the profession's interests to think about whether it should go higher than a basic level of competence. How are you going to compete with the ABSs, with the co-op? I think you're going to do so on the basis of quality. And you're going to find a way of demonstrating that quality. At the moment, the only real mark is of Queen's Counsel, and that's for very senior advocates and is of very little relevance to the majority of the solicitor's profession. Is there scope for much higher qualifications for conveyancing, for wills, for litigation? Should we be thinking about a Royal College model where you have centres of excellence in those areas so that consumers can find a way of establishing the best and most suitable lawyer for them? And those schemes, which can be profession-led because it is about professional expertise, could also be ways of checking on the integrity, on the probity, on the understanding of the cultural values that many people say will be compromised as a result of alternative business structures. Quite a lot of solicitors will object to that. They will say, I have my qualification, I want to keep it just being accredited. It does not make me any better a solicitor. That may be so, but I think those same solicitors will say, actually, there are a number of people in this profession who we would rather our families did not go to, who we would not trust if we were in trouble. And the regulators have consistently failed to identify the incompetent and the continually borderline poor practitioners. They're very good at rooting out dishonesty and breaches of the technical code and when people act with conflicts of interest. They've got okay at dealing with poor service, the not answering the telephone properly, the not giving the client proper information about pricing. They're not good at identifying when the work is poor. And sometimes that is because there is a long tail to the work. You may only find out that there's a problem, I was going to say after you're dead, but your legatees will find that, when you come to sell the house. When you find actually that the compensation you've achieved is pathetically small, the settlement you've accepted is too low, and you can't do anything about it. And there are a number of practitioners, not a huge number, but they exist, who are providing those services, and who I suspect many people in the profession would like out of it, and where the public would be better off if they were out of it. And we need to find some way which is practical of enabling consumers not to use those people, to go to the people who are good. And that, I think, is one of the significant challenges that this profession is going to face. So, let me go back now to the title of the lecture. What do you mean you're a lawyer? I've rambled over quite a wide terrain on it, but I hope what I've done is to demonstrate that there are questions arising from consumers and purchasers, from the economic climate and from the competition that is coming, which will change profoundly the way in which legal lawyers deliver their services. Yes, lawyers will still, I hope, I am sure, be people who advise, who help people out with their problems, who represent them, who do all the work that we've identified before and are quite ingenious enough to find substantially more. I think there's a huge opportunity, for example, for lawyers to become mediators, since the government is moving people away from courts. Tip for the lawyers here: train as a mediator. There is work there. But as a lawyer, you will be far freer in the way in which you practice, the method you choose to work, whether you're employed, self-employed, whether you want the risks of ownership of a business, or whether you're content to be an employee. I think you will specialise as a lawyer, and I think you will be required to demonstrate that you have that specialism, and that the challenge for the regulators is to maintain the core values of the profession and identify what those are, those core values of independence, of integrity, of acting in the interests of the client and in the interests of justice, and in achieving access to justice for people. And those values, perhaps, that 60-year-old correspondent of the President might well say, aren't that far away from his concept of being a gentleman. And they are the values which the success of the English legal profession, the outstanding success, which I think I've demonstrated over the last 60 minutes or so, has been based on. and which we have to maintain. Thank you.